where we start is with the course objectives. This comes from the part B, your contract. See, now I'm wandering over here. I'm just going to stay where I can be recorded. Basically, all of your courses will have this. This is a list of things that by the end of the course you should have achieved these things. So these are the things that we're assessing you on, because there's no point on assessing you on things that we don't care whether you achieve them or not. So this is what the Priestley 11 says you need to get by the end of this course. The Priestley 11, the university, the accreditation boards, all the rest of it. So we need to get to the point where you can demonstrate an advanced and integrated understanding of the legal framework for contract law. You need to be able to do some critical evaluation, that synthesis piece. You need to be able to do analysis and research, and you need to be able to demonstrate sophisticated cognitive and creative skills in approaching legal issues to do with contract law. So keep that in the back of your mind as you're thinking about where to focus your attentions. And finally, let's actually get on to the topic. So, what are the objectives here? I want us to walk away today having examined the nature and the role of contract, to consider the place of contract within private law. I want to have introduced to you the essential elements of a contract, and there are two parts to that. What I'm going to call the positive elements, so the things that you need to have in order to identify a contract, and the vitiating elements. Vitiating, a term that we have heard before or not? Any idea what it means? They're basically the things that mean that even though a contract might exist in terms of all of the positive elements being present, that a court won't enforce that contract. So a vitiating factor, a factor that breaks or removes the interest of the court in dealing with it. We need to be able to distinguish between the concepts of validity and enforceability. This is something we will keep coming back to. I don't necessarily expect you to answer that today. And what I really want to achieve is to give you an overview of the various elements of contract law, so we can look at the top of the jigsaw box and get into the balance. So, this is the high level. In this subject, we start off by looking at the elements of formation. They are roughly broken up into the following. You will say these over and over again. They will become your mantra. Agreement, which is also referred to as offer and acceptance. Consideration, certainty, and intention. If we have those things, we have a contract. Then we're going to look at the vitiating factors, or matters that affect the formation of a contract. Privity, affect the enforceability of a contract, not the formation of a contract. Privity, formalities, and capacity. I'm not even going to bother talking about what those things are at this stage. I just want you to know that they're there. And then we're going to head on to understand the terms of a contract. So it's going to be week 9 before we really talk about what the terms of a contract are. So they are the things that we do in fundamentals of contract law. In advance, you're going to look at all these other things. I'm not even going to list them here because we will run out of time. But we're going to talk about how contracts are discharged, the vitiation of existing contracts. We're going to talk about termination and the difference between void and voidable contracts in those exit circumstances. And when I say we, I really mean you. I won't be there. But my job is to get the foundations there for you. So that's the framework. Essentially, contracts are an integral part of business and society. The classical view, so those of you who did do the reading of the first couple of chapters will have identified these different views of just answering the simple question, what is a contract? The classical view is that a contract will enable parties to create their own private law. So what do I mean by private law? The study of law often asks us to look at what something is not in order to identify what it is. We look at the cases or the disputes in order to work out how to write a contract. So what would the opposite of a private law be? A public law. Absolutely. So does the language give you any giveaway? What kind of things might be public laws? Rowan? I don't know.
I was just going to say that it's about that the obligation arises out of the agreement of private individuals rather than an obligation enforced by the state or...
Absolutely. So Rowan said the obligation in a private law context arises because people have made a choice to be bound in some way. So by entering into an agreement, they've created a law amongst themselves, as opposed to an obligation that is imposed by the state or some other law. So a good example of public law is criminal law. It sets out, at risk of completely oversimplifying, that there are certain things that you can't do. They're called crimes, and depending on which ones you do, if you do them, there are certain kinds of punishments attached to that. Now, you can't murder somebody not because you've made a particular choice to be a particular kind of person. I'm not a policeman, therefore I can't murder someone. Actually, that's a little bit of a sad analogy. I don't think I really want to pull that one out too far. Murder is murder. The law says you can't murder someone. If the elements of the crime are proven, then the consequences follow. You can't steal things, but you can take a coffee out of a coffee shop if you pay for it. Which means you can, if you create a private law between you and the person behind the counter or the owner of the coffee shop, where I've got a contract, I will pay you for that coffee, you give me the coffee and I will walk out of the place, that is not stealing. You have created a private law between you that transfers the ownership of a thing from one person to another person. Judicial and legislative intervention have eroded the idea of freedom of contract. So this is taken straight from your textbook, by the way. Freedom of contract idea. What is the freedom of contract idea?
So the freedom of contract would be that you can essentially put anything inside of a contract. So there is legislation to protect that. Or there are certain basic rights.
So the private law idea is, provided that parties have agreed to it, they can do what they like. And you'll see this a lot coming through the common law cases. It doesn't matter whether the contract was fair or not. What matters is whether or not the elements of a contract were proven for a contract to be enforceable. So where we really see this is when we talk about consideration. And one of the elements of consideration, one of the maxim of consideration, is that consideration must be sufficient, but it doesn't need to be adequate. In other words, there needs to be consideration, and I'll talk about what that is, but for now, let's just use the word price. There needs to be a price paid, but as long as there's a price paid, it doesn't matter whether it's actually the right price or not, or a fair price. There just needs to be that element. Because this idea of freedom of contract is a very old common law idea that as long as the parties agree, they can agree whatever they like. Of course, we know that most contracts that we enter into, you can't negotiate. So the statutes have come in and said where you've got one party who dictates the term, there are certain things that they need to do. And they range from a range of implied terms that the statute requires, for example, statutory warranties or guarantees, through to rules that relate to the fairness in consumer contracts especially. So, and then, we have some judge-made law as well that impacts in those areas. Doesn't always sit neatly, but we'll explore that as we go.
You're talking a lot about case law before, so I'd say most law that's applicable to contracts is case law, not so much.
That's a really, really good question. So the question is most of the law that we're going to talk about to do, well, in fact, I've turned it into a different question, is most of the law of contract, is it coming out of the cases or does it come out of statute? I'm going to change that question slightly. The reality is that statute sits over the top and has eroded a number of the principles. But at the end of the day, we're going to be dealing with the contract law. It's actually what makes writing contract law questions really hard. It's because I need to be able to test you on the common law, and almost always there'll be some statute somewhere that I haven't thought about that's going to impact the way that a contract is actually formed in a particular area. So like I've given up on creating contract questions that deal with transfers of land, for example, or renting retail spaces. I think you even have problems with washing dogs and all sorts of things. So, you know, some of them are limited. So often you will find questions in the discussion board and the stuff I ask you to do in class, I'll say, just don't worry about statute for now. Let's make sure we understand how the common law works. But there's one piece of legislation in particular that sits over almost all commercial transactions, and that's the competition and consumer law. And it gets a subject all of its own, so I'm not going to spend too much time pushing into that. But we will, when we get to particularly topic 10, talk about the consumer law at some element. And you will need to keep asking yourself that question. Once you work out, is there a contract? The next thing is, does something else affect it? And in addition to the kinds of things like privity, capacity, etc., which are the vitiating factors that we'll look at from common law, you'll need to look at the questions in relation to statute as well. So basically in this topic what we're looking at is the basic principles, so we've got our launching pad. What is a contract? Elix, so many different responses. Just looking at your textbook. An agreement or a set of promises that the law will enforce. It's kind of a nice one, it works for me. Tritle, who's one of the most famous contract law philosophers, for want of a better word, defined a contract as an agreement giving rise to obligations which are enforced or recognised by law. Carter on contracts, that was the text that I had to use when I was at uni. There's another one called Cheshire and Fivefoot. They've been around for forever. They use the definition, any promise which the law enforces on the basis that it's supported by consideration. All of them are right and none of them are right. They all have issues with them. Once you actually work through the elements, you will see that a contract is something that you can recognise. You know it when you see it. But our job is to unpick each of those points so we can get around the problems with the definition or the accuracy. I was going to do that, but I am worried about us running out of time, so I'm not going to do another exercise. I'm going to tell you a story, actually. Well, I'll tell you the shorter version of the story because the rest is irrelevant. But I think about contract like this. I think about it in the sense of the rules of backyard cricket. So, I don't know, some of you look quite young, not all of you. When I was a kid, in summer, everybody used to play cricket out on their street, right? You get the rubbish bins, they used to be metal rubbish bins, and you'd basically block off 2 bits of the street and all the kids would be out and you would play cricket. And you would have a set of rules. So those rules might be over the fence is 6 and out is a common one. Everybody heard of that? You might have rules about how kids who were shorter than everybody else would get a second go on something. You might have rules about whether brothers could be on the same team or not, or whether kids from the same family could be captain or not captain. I'm sure there are different versions of games that kids play on the street or in the playground all over the place that have all sorts of sets of rules. But we all know that on a February night in daylight savings, when it's balmy and people don't all have air conditioning and you're outside. It's probably been the first time it's been cool enough to have any time, and you know, your dad and the other dads from the street are probably sitting on the back steps somewhere having a beer, and if it was my mum, she was probably yelling at somebody somewhere. But you know, you're out there and somebody's little brother has their first go and they send the ball over the fence. Everybody's just excited for them. They give them a 6 and let them have another go. Somebody's big sister's boyfriend has turned up and he wants to play, and you just think, oh well, it doesn't matter that he's like bigger than everybody else. If he wants to play on that team, it really doesn't matter because he's probably not going to be paying attention. Whatever, you bend the rules to fit the circumstances. But when it gets to about 8:30 at night and the sun's going down and somebody's mum is shrieking like a banshee from the back porch, the rules suddenly matter. Suddenly you're counting how many runs you get. Suddenly, if it goes over the fence and through a window, that person is out and they've got to go and get the ball from the cranky neighbour because the situation has changed. That's how I think of my job. My job as a contract lawyer is to write down those rules, that lowest common denominator between the parties. I've always thought of it as blokes, because they always were blokes. Blokes getting together and deciding the rules of their game, how much money they're going to spend, doing what, how long it's going to take. And we always know commercially that while people are getting along and while the circumstances are right, it doesn't matter what the contract says, it doesn't really matter what's agreed, you will find a way to do it while people are getting along. But when the market changes and the prices have suddenly gone down, or when a competitor's come out of nowhere with a whole new business model that you weren't expecting, when that key person from your business that you really were counting on suddenly ends up on staff from the other person, you know, the other side on the contract, suddenly the rules matter. And so being able to articulate clearly what the rules of that particular game are, in the knowledge that the only time that people will possibly look at that agreement again is when they're having a fight, is essentially what contract lawyers do. So that's, and it's like I might be being a little bit trite about a skill and a profession that's been very, very good to me over the years, but I think of it as writing the rules to a game. Thinking about all of the possibilities and allocating risks between people. And needing to do that in a way that if push comes to shove and there is a broken window, that I need a court to be able to enforce it. Or at the very least, I need my client to be able to convince the other side that a court will enforce it in the way that we understand that term to mean. I don't know if that's a helpful definition of contract or not, but that's where I start from. And I think thinking about the purpose of a contract is probably more useful to you in looking at the big picture view than thinking about each of the elements. The other thing that I started saying this before, the word contract is both a noun and a verb. We are involved as lawyers with the noun. We might say, and I have said, yeah, I just bought a $10 billion fridge today. I didn't buy a fridge. At best, I helped some people negotiate and document the agreement that they made so their respective companies could facilitate the purchase of this bridge or otherwise. So, you don't need an agreement or a contract. You don't need the noun in order to have a contract. The elements of a contract, and we've already spoken about them, you will get this mantra, are agreement, comprising offer and acceptance, usually, consideration, intention, and certainty. None of those things are writing on a document. At common law, if you have those things, you have a contract. Now, in certain circumstances, that contract may only be enforced if there is a formality requirement that has been met. So in other words, a statute somewhere has said this needs to be in writing, or some other formality needs to have been met. I'd love a statute that says people have to do interpretive dance before they can claim the money, but so far nobody's done that. So contracts can be oral, they can be written, they can be partly written, partly oral, they can be made in all sorts of ways. So, and the kind of writing doesn't necessarily need to be writing on paper either. You can make a contract provided that you have agreement comprising offer and acceptance, usually, consideration, intention and certainty. So, again, this time let's make sure that's on. Yep. Back to this again. So in that knowledge, you don't know what the laws are yet, but I'd be really interested to hear from you why you think we even have contract laws. We need a contract to... Oh, by the way, you've probably worked out, because somebody's done it already, if you like a particular response, you can vote for it and it will head up. So we need contracts to resolve disputes. We need contracts for accountability, to manage the inequity of knowledge, circumstances, etc. Oh, you guys are faster than me. So that people know their private rights and responsibilities when dealing with each other. I particularly like, can we talk about this one for a second? Oh, what am I doing? Timer, that's new. I don't want a timer. I want to be able to pin it.
Use the touch screen.
Yeah, I'm seeing something different on my touch screen. Oh, unless this one's a touch screen too. No, doesn't matter. Let's...
If you go above it and come down onto the pin, because you're going across the stage.
I think that...
I could be wrong. No, no.
Okay.
Yeah.
Okay. Let's talk about accountability, because that's the one I can... There's at least 4 or 5 people who think this is a good idea at the moment, so I'm not disclosing anything. Accountability of whom? Who's accountable?
Both parties.
Both parties? We're assuming multiple parties, or 2 parties at least. So the parties to the contract are accountable to whom?
To each other.
To each other. Anybody else? Any other stakeholders here?
Depends on what the contract is about.
Depends on what the contract's about, depends on how it works. So it's basically having a contract is a way of holding parties accountable. So the question was, why do we have contract laws? So can we pull that together? Because we've got laws, now I know you don't know what they are yet, but presumably you've got some sort of sense of what a contract law might do. It provides some sort of consequence that means that people are accountable. Is that right? I'm trying to take a one-word idea. I think that's interesting. I think it's good. It's good. There was one down here that I really quite liked that I wanted to... now this is an interesting one here. Come on, do something here. Introduce predictability and consistency into the practice of forming contracts. In the interest of time, I agree that that's what laws will do. Why does that matter? If we know that contracts will always, we already know, well, I'm assuming you're trusting me, in order for a contract to exist, there needs to be an agreement comprising offer and acceptance, usually, consideration, intention and certainty. We don't necessarily know what those things mean, but you're trusting me, I hope, that we have those things, we have a contract. So there's that consistency already. Why does that matter? Why is consistency important in a contract concept?
So that we can advise clients.
So we can advise clients, so we know we've got the algorithm, we know if A plus B equals C. But why do clients care about that? Why do people care about contract laws?
Under contract.
Sorry?
And They need to know if they're under contract.
They need to know if they're under contract. Rowan?
So that people can take the risk of entering into an agreement that's not going to be fulfilled immediately and have faith that it will be fulfilled.
So, excellent answer. So people have confidence when they take risk that they're doing something now in exchange for a promise of something in the future, that if that promise isn't fulfilled, that the contract law will enforce that promise in some way. I just used my language, legal language, to do it, but what you said was absolutely perfect. You back there, glasses. Sorry, I don't know your name yet.
Jack.
Jack. Hi,
I
Jack.
might have got the question wrong, but I was just going to say so everyone gets treated the same.
Again, consistency. So everybody gets treated the same. That is absolutely perfect. Commercial people are taking risk. That's a great word, Ryan. They're taking risk. So they need to know that when they take that risk, that the playing field is clear. One of the reasons that contract law doesn't change very much is because the economy works on the basis that people can contract, that they can trade, would be another word, in a consistent way. That as soon as you pull a lever, business people will talk about pulling levers. So as soon as, if you want people to do less of something, often a lever that government will pull is tax. I want you to smoke less, so I'm going to increase the tax. I want you to trade less with this country. I will increase tax on goods that come in and out of that country. But when we're talking about actual contracts that are enforceable in this jurisdiction, if the contract law is consistent, then business people and who are essentially investors, traders, people who make the economy move, know that things work in a consistent way. And consistency is something that is absolutely necessary to the economy continuing. So, excellent answer. Have a look at a few more here, just see if I'm going to treat that as certainty. So bind. Again, this is another really excellent idea here too. This feature, this response, that'll do. To create a common understanding and a system of interacting and trading. Look, I'm an unashamedly commercial lawyer. I'm a transactions lawyer. I've spent my life writing documents to buy and sell stuff. That doesn't mean that I don't care about the humans behind that and that I'm not interested in the way that they interact, but I think we need to come to contract law with an unashamed commercial bias and understand how it sits in an economic context. And that common understanding is a really important way of working out how the world works. So, what is the rationale for having a contract law generally? There is a commercial necessity. The principal reason for the enforcement of contracts is to facilitate trade and commerce, so that trade and commerce can occur in a consistent, enforceable, predictable and stable way. Contracts themselves, and I love the use of this word before, Ryan, risk. Contracts are about allocating risk, about deciding who is the best party to bear a particular risk. And writing a contract is largely about negotiating and identifying who should take on the risk. But there are also moral factors that sit behind the common law idea of contract. And this idea, this particularly Judeo-Christian concept of it's ethical for people to be bound by their promises. And we find sometimes some really inconsistent decisions, particularly in the older cases, particularly when this viewpoint comes down. And I find it interesting myself looking at some of the older cases, and I often find myself wondering if the parties were swapped around, if we would have the principle that we have today. So I'll point those out as we go and look forward to arguing with you. So the text that you had to read will give you a lot of different ideas about what a contract is and why a contract matters. I don't know whether it'll please you or disappoint you. I am not planning to go through each of these. They're there for you to read and to think about. Some of you will really connect with some of them, and they will help you, particularly those of you who are doing jurisprudence or otherwise, it will help you ultimately to get your own synthesis of the law, to sort of work out what your jurisprudential approach is. I'm going to be quite clear that I come to this very much from an economic analysis, and I come to these questions very much as this idea, pretty much the promise theories idea, the classical contract ideas. Partly that's probably how I was trained, but because I have always worked in very, very commercial contexts. That doesn't mean that I think it is wrong in any way for statute to come in over the top, particularly in areas like consumer protection. But I think as we understand the common law, that's the approach that I take. But I am certainly open to all sorts of different approaches, and I think the more that you compare and contrast different ways of thinking about even what a contract is, the better lawyers you'll ultimately be. So we have already spoken a little bit about private law, so I'm not going to keep going too much here. We sort of had that conversation. It's the thing I hate about slides. We end up sort of going in a straight line, and I'm not a very straight line sort of person. One thing I do want to point out to you really early on, because is there anybody who's done or is doing company law? Very few people do them. Are you doing it at this stage?
Oh, my bachelor.
Oh, your bachelor? So one thing I really want you to get your head around really early is, and you'll learn why and what it means later, but a company is, as far as the law is concerned, a person. Okay? An incorporated entity. So if it has Pty Ltd or Limited at the end of its name, even things that have Inc or otherwise, let's not worry about it too much. As far as the law is concerned, it has a legal personality. And in contract law, that means it can be bound in its own name. So companies that are incorporated can enter into contracts. Okay? And that is an important thing that I want you to remember. Don't know anything there? No. Do want to just touch very quickly on the differences between contracts and other types of private law. So really the focus of contract law is that contractual obligations are self-imposed obligations. The idea, particularly taken from the classical theory of contract and the private law theory, is that people come to contracts by choice. They assume an obligation. If all of the elements are there, then they are bound. And that's different from an obligation that's imposed by the law in another way. Contracts, again self-imposed, differ from tort in the sense that the duties that somebody takes on under a contract are only owed to the other parties to the contract, as opposed to duties that you might take on as a consequence of being a landowner, that in tort are duties owed to anybody who might be impacted by the choice that you've made. So a duty to avoid committing torts is a duty that's owed to everyone. But in contract, a duty to pay somebody some money is only owed to that somebody. It's also worth noting that you can have concurrent liability. So you could actually have an obligation that you take on under a contract and a matching obligation in tort as well. So we'll look at a few cases like that. Clayton and Hawkins is probably the most famous of them as we move through. So that case involves a duty in contract that a solicitor has to his client, and a duty in tort in relation to essentially the fiduciary duty owed in a particular set of circumstances. Equity still makes me shudder. Equity, what does equity mean? I've got it on the slide. I hate working to slides. I really, really hate working to slides. So equity relates in common speech to this idea of fairness. So at risk of boring you, and the thing is too, you should know, I did my degree in New South Wales where there was a separate court of equity, or equity courts, until 1972. So the courts were fused in Victoria in 1890 something or other. But basically, at risk of boring you with a really long story, common law was trudging along quite okay until a whole lot of people said, hang on a minute, your rules are very clear, but sometimes bad things happen to good people. We need to have a whole different set of courts that deal with fairness. So the equity divisions were created, and basically when people had a dispute in the very olden days, they had to pretty much make a choice about whether they'd have a common law fight or an equity fight. I am vastly oversimplifying stuff that you will learn somewhere else, but this is how I understand the story. So we ended up with some equitable principles that sit alongside the common law. These things were fused, is the language we use, as I said, in the 1890s, something in Victoria, when Victoria became a colony. In the UK, can't remember when exactly, but in New South Wales it was quite late. So the way that they taught equity so equity and trust, I think, is a subject that you do, but a lot of the equity parts of it we just had them drilled into us in the most boring way imaginable. I know, it's something that was about fairness. It just wanted to put you to sleep every day. I never really understood it. But basically these maxims work so that they will impact the way that a court might deal with a contract in certain circumstances. So we will talk a lot about certain remedies that might be available in equity, and certain equitable shortcuts, for want of a better word. You will deal with more of them in advanced law, and you will deal with a lot of them in equity and trust. But I just want you to be aware that there is a specific legal concept of equity. So whilst it's grounded in an idea of fairness, it's not as simple as working out, is this fair or not? Let's go with the fair way. In typical legal logic way, there is an algorithm that you essentially need to apply. You need to think about whether the maxims apply, and again, you're bound by the rules of precedent. So contract law is a common law jurisdiction, but sometimes equity will intervene and we talk about estoppel quite a lot in particular. Estoppel is an equitable remedy, and it kind of is what it sounds like. Estoppel is equity stopping someone from enforcing a right that they might otherwise have because of their conduct or because it would be unfair in some way. So we will touch on these things, particularly estoppel, because it keeps coming up in the cases. You will find it a little bit frustrating, but we can't teach you everything at once. So think about it, ask questions. And as we've already spoken about, contract law is also impacted significantly by statute. The ones we'll talk about the most are the Australian Consumer Law, referred to as the ACL. The ACL is Schedule 2 to the Australian Competition and Consumer Act. The Australian Competition and Consumer Act itself replaced the former Trade Practices Act. Why do I bother mentioning that? It happened 8 years ago or something like that. I think it came into effect in 2010. Don't quote me on that. Chances are I'll get the number wrong. But it's a long time ago. The reason for that is Section 52 of the Trade Practices Act is the single most litigated piece of legislation ever in this country. And it's now Section 18 of the ACL. So a number of the cases that you will read will refer to Section 52 of the Trade Practices Act, or the TPA. And old people like me still tend to just default to saying TPA, just the shorthand. I think I've got it out of my skin now, but you never know. So what does that do? In particular, and this is what section 52 did, it prohibits misleading and unconscionable conduct. So 52 or section 18 prohibits, I always refer to it as thou shalt not in trade and commerce, that is not a direct quote by the way, act in a way that does or might mislead or deceive someone. Doesn't matter whether you intended it or not, the question is, were they or could they have been misled or deceived? If they are, go to jail, do not collect $200. Not a direct quote. Contract law is also necessarily impacted by more and more international influences. International trade agreements or non-agreements, depending on what happens. There are international rules that relate to trade and commerce. Again, as the world gets smaller, consistency becomes more and more important. Some features that I want you to be aware of. Professor Google is my friend as well as yours. One of the things I learnt sometimes the hard way, working particularly in the UK but as well in the States, is contract law has a very universal feel. If you Google contract law consideration or whatever, you'll come up with a whole lot of stuff. Any of these elements. Be really careful, particularly the stuff from the States, because it's really easy. Their jurisdiction is quite different in a whole lot of really important ways, but really, really similar in a whole lot of others. And we can really easily end up in what I call parallel talk. In other words, we're using the same language and we're heading in exactly the same direction, but we never actually intersect. And the US in particular is grounded in a civil law system for much. It has a codified contract law, so there are some really significant differences to how these things play out. So be really careful when you're looking at this stuff, because it's similar, but it's not the same, and the outputs can be quite different. And we really do have a specifically Australian social and cultural distinctiveness in the way that contract law plays out in the courts.
That would be where the vibe of it comes in, right?
The vibe is really important. Really important. English decisions, since what, 78 or so? Might have even been earlier than that. I'm going to be really bad with the numbers today. I'll put it on the slide. Since 1978, we've no longer had appeals to the Privy Council. Now, you pretty much, most of you should get by now how precedent works, because the ones of you just did it last weekend. Essentially, if there's a court higher up in the hierarchy than the court you're in, stuff that they said, you have to follow. Which means until 1978, when the High Court, things that went to the High Court could be appealed to the Privy Council, stuff that the Privy Council said mattered. So even though English law and Australian law were different, essentially Privy Council trumped High Court. Since 1978, the law, we haven't been able to appeal, so in fact, those Privy Council decisions, those highest court English decisions don't matter from a precedent point of view anymore. They are and can be very persuasive, particularly decisions before 1978. Now, since 1986, Clayton Hawkins' decision I just mentioned, the High Court has really come out with the view that actually, even before 1978, they don't matter that much. So not binding, but persuasive. And we can learn a lot more from the UK decisions than we can learn from the US decisions. It's really frustrating for me because I practice in technology, and where do we get decisions from in relation to technology? We get them from the States. So we have to be really careful. What else do I want to say there? What are the essential elements of a contract? Now, I have repeated them a couple of times now. Anybody want to hazard a guess?
Offer and acceptance.
Offer and acceptance. I tend to call that agreement, which usually agreement equals offer plus acceptance. But not always. there is a twist in that tale, which we'll get to. So we've got 1, 2, we've got offer, acceptance, so agreement. Intention, an intention to enter into a legal relationship. There's one that we usually say before that, but it doesn't matter. Consideration. The shorthand word we're going to use that for that today is price, but it is so much more. And what else?
Condition.
I heard it over there. Certainty. Certainty. Now, one of the videos that you'll have access to, it goes in fact nicely with the discussion for week 2, is a little video that Andrew Valakanitis, I've probably said his name incorrectly, has put together on how to use Iraq. It's probably been given to you in other contexts as well. We like to recycle as much as we can. The one that I point you to is actually about a contract law question. And he talks about the 3 elements of contract. He talks about agreement, he talks about intention and consideration. He leaves out certainty. The reason for that is some people bundle up the idea of certainty with offer and acceptance. And a spoiler alert for next week, in order for an offer to be classified as an offer, it needs to be capable of acceptance on its terms. So to accept it, the offer itself needs to be put in a way that somebody just has to say yes and agree to it, which necessarily means it needs to be certain. So we're going to come around and we're going to do it properly. We're going to go old school because I think there is value in unpicking it. But we're not going to spend a lot of time on certainty for that reason. So, agreement. Again, offer and acceptance, but there's a twist in that. Sometimes we can't identify the offer and acceptance and we will still have agreement. Consideration, intention, and certainty. These are these 3 high-level vitiating factors that we will then talk about. Capacity is really about, are you able to enter into a contract or not? So I've already mentioned that companies are legal personalities. So they are able to enter into a contract. They can sue and be sued in their own names. A company can be a party to a contract. Formalities, we've already mentioned that. In those elements for a contract, agreement, consideration, intention, and certainty, none of those require writing. But some statutes will require a formality is met with. So we need to always, once we've identified that a contract's there, we need to ask ourselves a question, is there a formality requirement? And we'll talk later about what that is. And then the last of these is privity. Anybody want to hazard a guess about what privity is about? Please.
The parties to a contract.
Who the parties to a contract are. Can you remind me of your name again? SJ. Sorry, I should remember that. SJ. So, exactly. So one of the things I was saying before is when we think about a contract in terms of private law is a contract that requires the payment of a price to someone that can only be enforced by a party to the contract. So if I make a promise to pay Sarah, this is how I'm going to practice these names and I've not got to the back row yet, I make a promise to pay Sarah $50 and I haven't made that payment, then Jacqueline, you're Megan. I was going, yeah. Then Jacqueline could be incensed by that. She could be absolutely furious, and as she should be, but she can't sue me to make me pay. Unless it's a much more complicated contract than I have demonstrated. But on the understanding it's a simple contract where Jacqueline and I have contracted, she has done something for me, I've promised to pay her $50, I haven't paid it, she can sue me, but Jacqueline can't. So a vitiating factor is the privity factor. Now that sounds all pretty simple, but there are lots of circumstances where we end up with an unfair or seemingly unfair result because of the privity issue. Then lastly-ish, I can't see anymore where I'm up to on my slides. Here we go. We need to identify the difference between validity and enforcement. I'm really setting some general stuff here. Who's absolutely bored witless so far? Okay, so none of you are brave enough to tell me you're witlessly bored. That's all right with me. Oh, come on, what's going on? Come on. Come on, thank you. Okay, an invalid contract is not a contract. If a contract is invalid, it's actually not a contract at all. It's a misnomer to call it a contract. It's an attempt at contracting, but we don't have anything to enforce. It's like a phantom pregnancy. I'll take that analogy too far and it'll just get ugly. The Latin phrase that is used is void ab initio, so invalid from the beginning. By the way, I hate Latin. I really, really hate Latin. I genuinely think that lawyers only use Latin when the concept is so abundantly clear in plain English that it would be embarrassing to send someone a bill. My favourite Latin expression, having said that I don't like Latin, my favourite Latin expression is re ipsa loquitur. Do we have any Latin scholars here? It means the words speak for themselves, or the thing speaks for itself. If it speaks for itself, why not say it in English? I think the reality is one of the hardest things for most of you guys will be expressing these things in plain, succinct, understandable English. You will be surprised, I am every semester, how quickly you go from zero to hero with speaking the Latin terms and throwing out the big words and using the legal speak like it's awesome, but then turning it into from re ipsa loquitur to the thing speaks to it for itself. That's the hard thing. And that's how you know when somebody really understands something, is when they can take a complex thing and explain it back to you in a clear way. So yeah, I get absolutely pissy about the use of Latin. And so think twice before you use it in your advice. Of course, I love it when you make me laugh. So use it in an ironic way. That works and I'm there. So basically an invalid contract, no agreement. An unenforceable contract, on the other hand, it might be that the circumstances of that contract are different from different people. The little example that I just gave, Jacqueline can't enforce that contract against me, but Sarah could. I'm hoping she chooses not to, but she could if she wished to. So the circumstances are different depending on the parties involved. In the area of capacity in particular, particularly when we talk about the ability of children to contract, we end up in this funny situation where a child might be able to enforce a contract but can't have the contract enforced against them. So the circumstances can be different. So that's an unenforceable contract. And the agreement itself can be completely valid. There can be no issue with it. But again, because of some other vitiating factor, so for example, the Statute of Frauds Instruments Act, which essentially says unless you've got a written instrument, land can't be transferred. You can have a perfectly valid contract, but no instrument. So it's a subtle but really, really important difference, and the consequences for the parties can be quite different. So again, let me use the child example. If a contract with a child is an invalid contract, if it's void ab initio, then everybody gets their money back and gets to their starting point. But if it's an unenforceable contract, the child might be able to keep the goods, and you just can't enforce the requirement for them to pay for it. Quite different outcomes. And depending on the rules, and it's not just children, we could also be talking about inebriated people, drug addicts, the insane, the mentally infirm, people with Alzheimer's. There's a whole range of humans where we might have a capacity to contract question. The frustrating one is like 17-year-olds who have got, no other reason to, other than age on their side. I'll work out what's going on with the slides shortly. Is that you need to think about classification. One of the things that we will keep on doing during this subject is finding different models and ways of classifying things. I really want you to see this slide anyway. So there's a couple of different things. Firstly, we start with the form that contracts come in. And there are two that people get hung up on, in particular the bilateral and the unilateral contract. And we'll start talking about unilateral contracts next week. And when you read the classic case that brings us all together, which is Carlisle and Carbolic Smokeball, that will talk a lot about unilateral contracts. So what's a unilateral contract? Any ideas? SJ. Available to everybody. It's a good start. It could be, that particular case is about an offer to the world. So potentially it could be available to everyone, but for the actual definition of unilateral contract has a slightly different twist.
Is it like when it only requires one person to do an action or
one person to do an action or a thing? I think about unilateral contracts this way. I'm just going to see if there's a whiteboard. There we go, hopefully done. This is actually not that hard to understand, but I'm going to do this more than once. Unilateral, word comes from one. So you're right, one person doing one thing. If you think about a contract as a timeline, and we'll talk about this more, in order for a contract to be formed, we have the genesis. The moment of conception is when an offer is accepted. So in a unilateral contract, an offer is made, and then at the point that it's accepted, only one party has to do something. So a unilateral contract is accepted by action. So at the point of time that the contract is actually accepted, the accepting party has done everything that they need to do. The example we tend to use is I put up a poster saying, I'm going to use dog this time. I got in trouble about it. I don't particularly like cats, and I went down this whole cat. It just all ended in a bungle last time. But I put up a poster, my dog is lost. I reward $100, you find my dog. The minute somebody brings me my dog, they've done their bit, and the only person who has to do something is me. That's pay my $100. Okay, so only one party, at the point the contract is made, only one party has to do something. In a bilateral contract, both parties make promises, so I'll call it promise 1 and promise 2. At the point that agreement is made, where the offer is accepted, both parties have things that they need to do. Now, the classification unilateral or bilateral actually very rarely matters in real life, but it's one of the tools that you have. For some reason, it's one that we tend to get stuck on, so I just wanted to talk about it really early on. We also use this classification of simple and formal contracts. At the end of the day, I'm not sure what use that particular classification gives us beyond a formal or a documented contract is usually encapsulated in one instrument, in one set of things. But we know already that a contract can be created by orally, it can be created in writing, or it can be a bit of both. And there are particular rules about reading it when it's a bit of both. Other classifications are to do with effect, which we've already spoken about, the difference between void and unenforceable. And then the last thing that we do need to think about occasionally is the difference between an executed contract and an executory contract. So anyone want to hazard guess? I'm using technical language just to make sure you've heard it, and we'll keep reinforcing it. Often when we talk about signing a contract, we'll use the words, lawyers will say, oh yes, they executed that contract. But technically, an executed contract is a contract where everybody's done their stuff. And an executory contract is a contract where people still have obligations to perform. So in this example, this is still an executory contract until that money is paid. In this example, if I was using promises, we'll just use, I promise to pay you $2.80, you promise to give me a small black coffee. It could be that the handing over of the money and the coffee happen at identical moments, and that the agreement is made, in an instant, and it's just done. Somebody's there with the coffee in their hand. I'm just like, I'll give you $2.80 for that. More often in that example, you would have probably 3 minutes in between an offer and acceptance. Both people have promises. It may well be that you pay the money and then you're waiting for your coffee. There might be a point in time where it's executory. It might be very short. So again, why bother with this? Partly because it's unfamiliar language that we need to use in a really precise way. But mainly, these kind of tools will help us make sense of these things. So don't worry, you don't have to remember this, just introducing this idea that there will be different kind of tools and classification methods we use. Why am I going to talk to you about them? Not because I really like fancy tools, because they will help you with sense making and applying it going forward.